Okay, hello. Hello, everybody. Hello. Hi, hi, hi. I'm back again. My cough has settled down a little bit. So many things to do, right? Welcome in, everybody. Get myself sorted out. Lumpy blankets. Hello. Okay. I'm so scared of losing hope. It's going to be okay, Felix. It's going to be okay. And these are scary times. These are nerve-wracking times, but we will get through them. I know we will. Pamela Joe, I know, Skeleton Key. I know, I was thinking that same thing. I know it. All right. Yeah, these are a bit scary times, everyone. I understand. Hello, Steffi. We're back again. Don't call it a comeback. I've been here for years. Yes. Well, there's just so much to go through. So I can't do super long lives because I'm still too sick, but we can do some minis. Hello, Just Mom. Welcome in. Good to see everyone. So, excuse me, forgive my cough, but the show must go on. Well, that's a good one. It's a good one to have. Oh my gosh, my desk is getting so messy. James Madison's buried under Post-its. I just freed him. Sorry about that. Post-its everywhere. Oh, goodness. Yes, Pamela Joe. Oh my gosh. Excuse me. I know, Barbie. Oh my gosh, that was so good. It was so good. Saturday Night Live right now. And South Park. I'm not a big South Park fan. You know, maybe 20 years ago was all right, but I tell you, they're doing good work. How the closet doors. Yeah, I've had to move. I've added an additional closet door that's gone across, and then I still have 3 phone boards. So there's that. Now this will settle down in a minute, so I apologize. Hi, H. Titus. Welcome. All right. Yeah, I agree. All right, everyone. So I was on a little bit earlier today going through the Chicago lawsuit against the feds for harming the press that have been out there, along with individuals who've sustained injuries because of excessive force, according to their complaint. So I did that one earlier today. When I had hopped on, I had asked if anyone was interested in me finishing up this ethics complaint. There was an ethics complaint against Bondi that had been set out. And this is like one of the bigger ones that I've seen here. Can I help you, ma'am? Sorry, my cat. My cat's coming over. Anyway, so this is pretty significant. They're very organized, as you would expect. But I'd only made it through the first half. And I said, hey, does anyone want the other half? And a lot of people said yes. I thought, well, let's just do it. All right. So this is Pam Bondi, who is the AG right now. Now, what you don't want, everyone, is the AG to have ethical complaints filed against them. Now, you might say, well, it's not been proven. We don't have it proven. We just have the complaint. But even just getting the complaint is not a good look for your attorney general. All right, it's just not. So this was filed June 5th, so we'll go ahead and put that date here. So we don't, what? My pens are cold. It's cold where I'm at these days, so. Right, the paralegals. Exactly. All right, June 5th. Again, I do apologize for the coughing. I do try to move away from the microphone, but unfortunately, I just can't seem to get get rid of it. So, all right, here we go. Excuse me. Get rid of it. So, all right, here we go. Excuse me. Here we go. So again, I had read through the first part of this complaint previously and thought, well, let's go ahead and grab it and go through it again. So I'll just read the introduction piece here because that gives you some idea of where they're going to be going. And then we can kind of dive into the facts and the evidence that they are using to show that there is an ethical violation. I do feel better. Just haven't quite been able to get rid of this cough yet. So that sounds like kind of what the deal is right now. So with that, I'll go ahead and dive on in. Again, I'll read the first couple pages and then we'll kind of fast forward to where we stopped. Yes, I have lots of water. I've got tea with honey. Good afternoon, Simply Carrie. I've got some throat spray, so I'm pretty good. I'm not sure much else. I have been steaming too, so I've been doing that. All right, I have to save my words for the most important things. So let me go ahead and dive in here, everyone. All right, we've got an ethics complaint against Miss Bondi. Now, she is licensed out of Florida, right? And so down here you can see her Florida bar number. Now, I'm not doxing anybody. This is public information, as it should be. My bar number is public information as well. Here's your contact information currently if you are interested in that. This is something you can pull up online for free and read it yourself. You would just, type in what we've got here as the title and it will pull it up for you. Yes. All right. So here we go. The undersigned attorneys, law professors, and former judges. That's not a good start for her. File this complaint seeking an investigation and appropriate sanctions against Pamela Jo Bondi, a member of the Florida Bar, who has engaged in serious professional misconduct that threatens the rule of law and the administration of justice. And then the rest of these footnotes I will skip past so we can kind of get to the meat of it. We file this complaint recognizing that Ms. Bondi currently serves as the Attorney General of the United States, the highest ranking lawyer in the United States government. Indeed, we bring Ms. Bondi's misconduct to your attention precisely because Ms. Bondi holds this exalted position, with the attendant responsibilities for subordinate lawyers under her authority who carry out her directives, and because the complaint highlights for the entire legal profession the importance of ethical rules to our independent, self-regulating profession. So that self-regulating bit is, worrisome. Likewise, we file this complaint notwithstanding the Florida Bar's recent reply to 2 previous ethics complaints filed against Ms. Bondi that it does not investigate or prosecute sitting officers appointed under the U.S. Constitution while they are in office. So this is the key. They're saying we've got ethical complaints, and then the Florida Bar is saying, well, we don't investigate if they are, if they rank high enough, we won't investigate, which just seems like that would be the ones you would really want to investigate. But alas, that's not what they're doing in Florida. The purported rationale for declining to investigate or prosecute is that such action could encroach on the authority of the federal government concerning these officials and the exercise of their duties. The Florida Bar's dismissal is unsupported by history or precedent, as the Supreme Court has held, quote, since the founding of the Republic, the licensing and regulation of lawyers has been left exclusively to the states and the District of Columbia within their respective jurisdictions. The states prescribe the qualifications for admission to practice and the standards of professional conduct. They also are responsible for the discipline of lawyers. All right, and this is the Flint case, if you are interested, 1979. All right, so that's kind of our intro paragraph here. And then they start going into what the problems are. All right, so here we go. Accordingly, let's go back up to the policy piece right up here. Accordingly, this policy of the Florida Bar is abdication of its jurisdiction and its responsibility to regulate the legal profession. Indeed, this policy means that the bar will exercise no authority over the behavior of lawyers licensed in Florida who happen to be appointed as an officer of the United States. In other words, any such lawyers, including the Attorney General, are professionally unaccountable. So this kind of a huge deal, right? Now, when we were back in the Georgia days, when we had 19 defendants, which that case is still going, it's just on a bit of a pause for the moment. But when we were back in Georgia, hold on here, I gotta get my visual aid out. Here it is. So when we were in Georgia, we had half of the defendants were attorneys, right? So Eastman, and he's lost his law license. Giuliani has lost his, two of them, actually three maybe. Smith, I don't know what's going on with him. He was a local attorney. Cheesebro here had his license revoked in a couple places. Sydney Powell, she has not been touched. She is licensed through Texas. Jenna Ellis, she has had a public admonishment, and I believe her license is in question, but I'm not sure if it's been fully pulled yet. She's out of Colorado. And then down here, this Clark fella, right? So Meadows was the second in charge, but this Clark fellow, Jeffrey Clark, did have his pulled as well. And then we've got another local Atlanta area attorney, and I don't know what's happened to his license. I will tell you my idea of why we're having everything destroyed the way that it's being destroyed, truly, is because Mr. Eastman has a huge history of constitutional law and of teaching constitutional law. And when you do that, you see where the weak spots are. So I truly believe that Mr. Eastman is playing a role in all of this. Maybe he's just friends with Stephen Miller, but that's my suspicion. Right? So again, just to remind everybody, these are the 19 people who were charged with a RICO offense regarding the last, civic duty, put an X in the box day. All right. So just like to show that, right? Because this is an actual criminal investigation. And yes, it is continuing on. All right, here we go. So we'll start with the summary of the complaint. The gravamen of this complaint is that Miss Bondi personally and through her senior management has sought to compel Department of Justice lawyers to violate their ethical obligations under the guise of zealous advocacy. Now, at this point, I would say I think they've lost about 2/3 of the attorneys there. As announced in her memorandum to all department employees issued on her first day in office, threatening employees with discipline and possible termination for falling short, she has exerted this pressure even though the rules of professional conduct limit the zeal of attorneys to lawful and ethical measures. Such conduct violates Florida Rule of Professional Conduct 4-8.4a, which makes it misconduct for a lawyer to knowingly assist or induce another to violate the rules of professional conduct, which imposes ethical duties on Ms. Bondi to take reasonable measures with respect to her managerial duties as Attorney General and her supervisory duties over subordinate lawyers to ensure that lawyers in the department comply with their ethical duties, and Rule 4-8.4d, which prohibits a lawyer from engaging in conduct that's prejudicial to the administration of justice. Like that's important. Here, oops, I'm flipped. In this complaint, we highlight 3 glaring examples of department lawyers being terminated or forced to resign as a result of demands that they act unethically issued by Ms. Bondi or a member of the senior management, including Emile Beauvais, who's now a judge, initially the acting deputy attorney general, the number 2 position in the department, which is now a different attorney. And now the principal associate deputy attorney general, number 3 position, Todd Blanche, is the current deputy attorney general. And Edward Martin, then interim U.S. attorney for the District of Columbia, and now chief of the Justice Department's Weaponization Working Group and department's pardon attorney. So this fella right here, this Edward Martin, he's no good. This fella's no good right here. Let me see if I have a picture. I might have, did I save it? Let me see. I tried to pull out all of the bad guys, all of the villains, I guess, in the Attorney General office. So let me see here. We've got this guy, Eric. Oh, here we go. Is this it? What's his name? Edward. Oh, nope, that's not him. Eric Edward, you know what I'm saying. Yeah, I guess they don't have a picture of him. But yeah, so he's one of the dudes. Now, he should not be in charge of pardons. He is barely hanging on by a thread of knowing how to actually be an attorney. So his reputation is monstrous, if you will. So, jump scare. Sorry about that, Carol. I'll give you a heads up next time. Sorry about that. So Edward Martin is in that position. And again, as the pardon attorney, where the pardon powers of the president are basically untouchable. This is the one area where the president can literally, if someone gave him $1 million in order to pardon them, he could do that without being charged criminally. Now, it would be grounds for impeachment, and we all know how that goes, but that would be a really big deal. In the simplest and most alarming example, Miss Bondi and her deputy, Mr. Blanche, fired an experienced and accomplished attorney, Arez Ruveni, for telling the truth before a tribunal in the case involving Kilmar Garcia, who was deported to El Salvador due to an administrative error and contrary to a court order that he not be deported to that country. Let's pause for a minute. Mr. Ruveni, right, had been there, and they'll go into more details. He's the one that said it was an administrative error because he didn't have any information. This is the man. This is the man that made it possible to locate Garcia and to bring him back. If this attorney hadn't stood up in court and said administrative error, we may have never known. So I would say this is one of the heroes, all right? Do I like him personally or not is irrelevant. But this attorney is a hero because, again, he stood up and he said administrative error. He was fired for it, as we'll hear. But because he did that, we're able to go after and try to help the hundreds of others that were illegally taken. All right? So very important here. For telling the truth before a tribunal in the case involving Kilmar Garcia, who was deported to El Salvador due to an administrative error and contrary to a court order that he was not to be deported to that country. The second example is the forced resignation of Denise Chung, who had served the department for nearly a quarter of a century when she declined to open a criminal investigation because there was insufficient predication. Now, again, Ms. Chung, one of our attorney heroes, 25 years experience. Now, if you've got an attorney with 25 years experience in one particular area, they're basically, they're like unicorns. It's so rare. So someone with this much experience, to let them go, that's huge. That's a huge problem. And third example of this pattern of conduct occurred while the department proposed to dismiss a criminal indictment of Mayor Eric Adams out of New York. So let's just make sure I put the 25 years down here for her. That's her experience. And then Ruveni, who stood up. Oh my gosh, stood up. Here. All right, to dismiss a criminal indictment of Mayor Eric Adams of New York without prejudice in exchange for Mr. Adams's assistance on immigration enforcement. Because the dismissal was based on an improper quid pro quo, the acting U.S. attorney for the Southern District of New York and almost a dozen other lawyers in that office and the department's public integrity section objected to the proposed dismissal. As a result, that's my cats, they're sneezing. As a result, they were forced to resign immediately or placed on administrative leave, and later resigned rather than express regret for the prosecution. So there's our third one. All right. So we have forced resignation. Again, this was all the way back in June, so their whole squad hadn't been fired yet. That's coming up. Through her zealous advocacy memorandum and its application in these 3 cases, Ms. Bondi has sent a message to all Justice Department lawyers that they must disregard the applicable rules of professional conduct, fundamental ethical principles, and long-standing norms of the department in order to zealously pursue the president's political objectives. And if they fail to do so, they will be disciplined or fired. However, as Ms. Bondi and her senior staff are fond of saying, no one is above the law, and this includes Ms. Bondi. So another important thing here, and again, I'm going to kind of zoom through this because I had stopped reading in the middle. But one thing to remember, right? We've got a U.S. Attorney General, which I will tell you right now, any of the scandals involving the president, right? Like the JFK situation, the Nixon situation, all of those where we've had some presidents with some questions, look and see what happened to their AGs. Because it seems like there is almost always an AG involved, and the AG is taking the hit, going to the prison, doing the accountability. So just keep that in mind. The Attorney General is in the hot seat. If the president screws some stuff up, they're going to go after the AG first. So just remember that. Hello, Brian. Welcome in. Good to see you. Hi, Dolphin. Hello, T's Oasis. Oh, I could use an Oasis. Hi, Allison. Tiffany, good to see you. Hello. If I didn't already say Dolphin, hello. If I did, there's your second one. So keep that in mind when it comes to the AG's office. All right, that's very important. Right, she fired all the people that were responsible for ethics. True. Right. Yeah, Nixon's, AG. Exactly. Good afternoon, Dano. So I think that's really important to remember. And the second thing that is really important to remember is the Attorney General represents the people of the United States of America. She does not represent the President of the United States of America. That piece is what they are jacking up here. So what the executive is saying, they're saying that the President is the people of the United States of America. So the AG's office is his attorney. That is incorrect. And they think that because they got some votes, that he is the one to be represented by the Department of Justice. And that's not the case, but they're certainly playing on that quite a bit. All right, here we go. Right, so here are going to be some examples. All right, so we've got some facts coming out here. Right, not his personal attorney, exactly. Right, it is gross. It is gross, and the more times you say it, the more it starts to be like, oh yeah, I heard that. Oh yeah, okay, I guess that's right. But no. Just also the cabinet. Let's talk about that for a second. She is on the cabinet, and he picks who's on the cabinet, right? Obviously. And the Attorney General's office is a part of his cabinet. But again, the attorney there, the AG has another set of rules that they have to follow just because they are an attorney. So that's what we're talking about here. They're like, oh, we don't want to investigate because, they got appointed. Fine. But on the other hand, the AG is not exempt from ethical duties, and that's what happens. Right, it's possible to impeach them, Kristen, Section 4. Oh, the juncture in the cabinet. Interesting, and I think that's accurate. All right, here we go, back in it. I have to save my voice here. I have to tell myself to save my voice. Number one, factual statement. So, Miss Bondi's zealous advocacy memorandum. On her first day as Attorney General, February 5th of 2025, Miss Bondi issued a memorandum to all Justice Department employees entitled General Policy Regarding Zealous Advocacy on Behalf of the United States. Now, our footnote down here, number 4, right? So they're just citing the page, so we know where it's from. Number 1, it's the job of an attorney privileged to serve the Department of Justice to zealously defend the interests of the United States. Those interests and overall policy of the United States are set by the nation's chief executive, who's vested by the Constitution with all executive power. More broadly, attorneys are expected to zealously advance, protect, and defend their clients' interests. Department of Justice attorneys have signed up for a job that requires zealously advocating for the United States. So see what she did here? She said, you are zealously advocating for the nation's chief executive, right? I mean, this is awful. Number 2, the responsibilities of Department of Justice attorneys include not only aggressively enforcing criminal and civil laws enacted by Congress, but also vigorously defending presidential policies and actions against legal challenges on behalf of the United States. The discretion afforded department attorneys entrusted with these responsibilities does not include latitude to substitute personal political views or judgments for those that prevailed in the election. All right, another. So prosecutorial discretion, and I'll just remind everybody what that is. It's when a prosecutor decides to take a case or not. Probable cause can get you an indictment, sure, but probable cause is not guilt beyond a reasonable doubt. So sometimes a case will get indicted, but there's just not enough to take it to trial because you have to have enough in order to take it to trial. And so what she's saying here is we're going to have discretion when it comes to anything that is positive or negative regarding the president's agenda. All right. So maybe we wouldn't normally prosecute certain cases, but maybe we will now. The best example I can give you is the TikTok case, right? So we have a statute, congressional statute that was approved by the Supreme Court, which I disagree with. I believe it is a First Amendment violation, but alas, I'm not on that bench. And so there's the rule. Under the rule, some things needed to go down, and those things have not gone down. So they're using their discretionary power out of the Attorney General's office to say, you're not in compliance, but we're not going to charge you, right? So and that's an example of what we're talking about here. You interpreted, yes, interpreted that differently legally. Ooh, which piece, Pearly Gray? You're welcome. Contrapositive. I know. I know. Yeah, it's worrisome with the Constitution. Right. Well, we do our best. Here to try to do that. Oh, hello, Stephanie. The last paragraph. Thank you for doing this. Oh, all right. Right. Exactly. It's going to be based off of what that person believes. A grand jury can indict a ham sandwich. Cowboy Satanist, listen up. We had a Subway sandwich situation occur already. All right, we've proven it. There was a sandwich involved and an assault. And 3 times the grand jury came back and did not indict. So let's not forget the sandwich case, all right? Sandwich gate. So the ham sandwich doesn't work anymore. The sandwich won. It did. The sandwich did win. All right. Oh, my goodness gracious. Okay, sorry, everybody. I have to keep the... You know what I'm saying, cowboy. Oh, my gosh. Lest we forget the crazy times we're in. Well, it's interesting that you say that it's turned into a weapon because the executive order involving the flag burning stuff, right? I went through that executive order, and the big thing is that the executive order says you can't use the flag as a weapon. And I kept thinking, like, how would you do that? How would you use it? I mean, I suppose you could Excuse me. I suppose you could. I'm sorry, it makes me laugh so hard. Right. I'm not sure exactly how you would use a flag as a weapon, but that's what the executive order. Stop by to say hi. Oh, thanks. Excuse me. Oh, Josu. Oh, thank you so much. Oh, I appreciate that. I'm so glad you can come by and hang out with us. Just trying to get some information out there for everybody. It's more. Oh, good point. Oh, if you ate it. Oh, or force somebody else to eat it. Okay. Thank you very much. I appreciate that insight. Oh my goodness. Get Snapple with it. All right, here we go. The moral of that story, read those executive orders carefully. Don't trust the media. When Department of Justice attorneys, for example, refuse to advance good faith arguments by declining to appear in court or sign briefs. I apologize. That's a big one, right? If we didn't have any attorneys showing up for the DOJ in court, that's pretty big. It undermines the constitutional order and deprives the president of the benefit of his lawyers, which is in italics. It is therefore the policy of the Department of Justice that any attorney who, because of their personal political views or judgments, right? So you have to judge something to see whether or not you can take it all the way to a jury, declines to sign a brief, which was happening, or appear in court, refuses to advance, refuses, here we go, or otherwise delays or impedes the department's mission, will be subject to discipline and potentially termination consistent with applicable laws. So yes, so she's saying you don't get to not do a case. If I'm going to give you a case, I don't care if you think it's ethical or not, you still have to do it. Now that does not work very well. That does not work very well at all with attorneys, right? Because when we graduate and they give us that doctrine, that's like an extra ego. So you're coming in here and you're saying to an attorney, you do what I tell you, and if you don't like it, too stink it bad. Pretty much like what Mr. Orange said to all of the highest ranking military in Quantico. Well, if you don't like it, you can leave. And then if you leave, we're going to take your rank, right? Very similar type situation. So she got some pushback on that. As subsequent events demonstrate, the zealousness intended by Ms. Bondi's memorandum entails the routine violation of ethical strictures applicable to department lawyers and has resulted in these lawyers being fired for complying with those limits or forced to resign after, rather than violate their ethical obligations. So I think that's really important. Yeah, it seems as though the ethics aren't needed anymore, which of course we all know is not okay. So what I have coming up next, they go through the ethical issues that were in play with the Abrego Garcia litigation. All right. So much has changed since they filed this, which was in June. We've had a lot of things change. So I'm going to skip through this, but just pointing out again, the attorney, Mr. Roveni, and how he basically stood and said, like, no, this was a problem. Next, we have the EPA Clean Energy Contract investigation that was set up, right? We've got Ms. Chung, who served for 24 years in the Department of Justice and the Attorneys General's, and the U.S. Attorney's Office for the District of Columbia. She was most recently chief of the criminal division of the office. On February 17th, Department's office and Deputy Attorney General, then headed by Mr. Bove in an acting capacity, instructed Ms. Chung to open a criminal investigation into whether EPA had unlawfully awarded a clean energy project contract and to issue grand jury subpoenas pursuant to the investigation. She was instructed to take that action by close of business that evening to prevent contract awardees from drawing down the contract funds held by Citibank. Ms. Chen conferred with colleagues with substantial white-collar criminal prosecution experience, reviewed documents provided by the ODAG, and concluded the documents on their face did not provide the predicate for opening a criminal investigation. After much internal debate, ODAG said a freeze letter requesting that the bank freeze all the funds would be adequate. Ms. Chang, I apologize, I'm saying her name wrong. I apologize. Yikes. Ms. Chang contacted the FBI's Washington field office to start that process. She also viewed the Project Veritas video that ODAG claimed provided probable cause. She sent a draft freeze letter to the principal deputy U.S. attorney for the District of Columbia. That person proposed inclusion of language stating the government had probable cause to believe that contract funds held by the bank were subject to seizure and forfeiture. Ms. Cheng said the language was not appropriate based on the evidence she had received. She provided the FBI with an alternative language that said there may be an investigation or there may be a conduct that constitutes potential violations of the Federal Criminal Code that merits additional investigation. The FBI issued the letter to Citibank at 7:28 p.m. Now, the PASA, the interim U.S. Attorney Martin, called Ms. Cheng. Ms. Chu? Oh no, I even made a note to myself. Ms. Chu. Oh my goodness. Shortly afterwards, objecting to the language of the freeze letter and directing Ms. Cho to immediately send a second letter to the bank signed by herself and Mr. Martin, announcing the commencement of a criminal investigation and ordering the bank not to disperse any funds, which, by the way, is a threat. If you've got a federal prosecutor calling you up and saying, we're going to file charges against you if you don't do what we tell you, that's illegal. That's like the most clearly illegal thing ever. She responded that she continued to believe there was insufficient evidence to issue such a letter, including insufficient evidence to tell the bank that there was probable cause to seize the accounts that had been identified, because she believed she did not have legal authority to send that letter. So she told, I know, right? Martin, she would not send it. Mr. Martin then asked for her resignation, which she submitted the following day. Mr. Martin then personally submitted an application for a seizure warrant, not signed by any other prosecutors in his office. A U.S. magistrate judge rejected it on the grounds that the application, which included an affidavit from an FBI agent, failed to establish a reasonable belief that a crime had occurred. So just not even the most basic level. Mr. Bove then approached at least one other U.S. attorney's office in the southeastern U.S. about launching a grand jury investigation of the same contract and seeking a court-ordered bank freeze. But prosecutors in that office also refused to do it. So again, I pull it diagonally when I know this language up here can't be seen, because I try to keep the chat on the blue as best as I can. But I usually don't do that. Anyway, so you can see here some blatant violations, right? That's what happens. Like, you tell them they're going to go to jail if they don't, do what we tell them to do, right? So it's pretty atrocious and an abuse of power, without a doubt. All right. Yeah, no problem. Well, yes. And this has continued. This has continued throughout the entire administration, right? We've had multiple lawsuits. The Inspector General's, which is a different office, but those in charge of making sure everything's running ethically, that was like the first termination. I think that was the very first executive order, actually, the day he was inaugurated. So we know there's some problems in here, but again, what happens is we see these issues going on, and then we say, all right, well, this is the Department of Justice. This is Bondi's mess that she created. So let's investigate her. And then Florida comes in and says, we don't investigate anybody who is in this kind of a position. So again, the question is, shouldn't it be the higher the position, the more important it is to investigate that they're doing things ethically? But that's just me, apparently. Right. Fraudulent. Exactly. I mean, this is just, and if you also, as I get another cough drop here, everyone, this is also a really good example of where Bondi has another a task. If you look through these executive orders, everyone, which, you know, I've been doing because so you don't have to, you will see that the amount of jobs given to Bondi and to Hegseth and to what's his name, the Florida fellow with the glasses, Marco fella, those three people basically in every executive order are told to do something. There's a task in each one of them. So I think it's very interesting how he's using the cabinet members to do all of this stuff. Yeah, Marco, thank you so much. Rubio, right. To do that. Oh, I'm happy to help. Hopefully this kind of gives you a better idea of what's going on. I just wish my cough was completely gone. All right, I'm going to dive back in. Just need another. This is not sponsored, but Eichmann. I'm not sure without my chart. I don't remember which position he has. Ken! Oh my gosh. Good to see you, Ken. Thanks for swinging by. All right. Oh, yeah. See the paper on the table. Exactly. All right. So next up is the dismissal of Eric Adams's prosecution. I'm sure everyone kind of knows what happens here. They're basically saying, we'll drop it as long as you do what we want you to do when it comes to immigration. That's not cool. Okay. And then it's just going to keep going on and on. We've got letters of resignation going back and forth, which were tremendously disturbing that they would do that to a veteran prosecutor. Next, we've got ethical rules that have been violated. So that's where we will pick up here. For those of you who... Oh, okay. Oh, dear. Doughboy. Oh, my goodness. All right, I got you now. All right. Hi, Amanda. Hello. So this is not a court filing. This is an ethical complaint. This was filed by a group of lawyers, judges, and professors. And I will show you here because they are all listed in the back. So we have these that are the first ones, and then we have 2 pages of people here, different attorneys and professionals who signed off on it. All right, let's take a look then specifically. Whatever happened with this, it's still rolling around. The Florida bar responded, we're not going to open an investigation on someone who is in a position that they were appointed to. So at that time. So again, though, she can get pulled out of that position. If she gets pulled, either impeached or she has to leave, she gets fired or whatever, gets on the wrong side of Mr. Orange, as soon as she's out the door, then you could go forward. But these are ethical, not criminal charges here. Criminal charges, that's a different animal. All right, let's take a look here. Ethical rules that have been violated. Applicable rules of professional conduct. Number 1, Miss Bondi. The McDade Amendment. Am I squared up here, everybody? I just want to make sure everyone can see this okay. Right. Okay, it seems to be okay. Okay. The McDade Amendment makes plain that an attorney for the federal government's bound by state laws, ethical rules, and federal court rules in the state where such an attorney engages in that attorney's duties to the same extent and in the same manner as other attorneys in that state. So they're just saying we have requirements here for Florida. That's where she's licensed out of. Miss Bondi is a member of the Florida Bar under Rule 4-8.5 of the Florida Rules of Professional Conduct. She is subject to the disciplinary authority of this jurisdiction, although engaged in practice elsewhere. The comment to this rule adds, in our comment section out of our professional rules of ethics, is super important. You do not want to skip the comments because that's going to help you figure out what the rule actually means and how it's to be applied. So, in modern practice, lawyers frequently act outside territorial limits of the jurisdiction in which they are licensed to practice, either in another state or outside the United States. In doing so, they remain subject to the governing authority of the jurisdiction in which they are licensed to practice. If their activity in another jurisdiction is substantial and continuous, they may constitute the practice of law in that jurisdiction. So, especially if we're going into the Washington, D.C. zone, right? you can, first of all, get your license in DC, but also, as long as you're licensed somewhere else, you're going to be good to go. What's the name of the writing style? I'm not sure what you mean. This is an ethics complaint filed by a whole bunch of people. I fail to see how the manner you got your job should be a factor in an ethics complaint. Well, I don't know what you really... Oh, the font. All right. I don't really know what you mean here. If the rules of professional conduct in the two jurisdictions differ, principles of conflict of laws may apply. Similar problems can arise when a lawyer is licensed to practice in more than one jurisdiction. Oh, MLA or... Oh, okay. I have no idea. This is just law land. So I would refer to it as blue book. Blue book. If you're an attorney out there, I'm sorry. I just gave you trauma. Yeah. English literature writing. Oh, I don't know. Why is there a difference if she's appointed, hired, or retained? Okay, I got you now. I got you. And they are afraid that it will have negative consequences on her authority in her job. All right. So that was flying way past me here. But yeah, that's the issue. And they put that out. That's one of the very first things that they're talking about here. They're saying, look, as a Florida bar, right? They're saying complaints filed against Ms. Bondi that it does not investigate or prosecute sitting officers appointed under the U.S. Constitution while they're in office. And they're saying that again because it could encroach on the authority of the federal government concerning these officials. We're going to get into trouble, though, because she is already losing all kinds of respect, right? So her reputation her credibility is already being flushed. Oh, yeah, of course. Hi, Betharo. So that, I think, is one of the big issues here as well. So here we go. Next up, the department lawyers. All right. Under the department's choice of law rules, the department lawyers that Ms. Bondi and her senior management team supervise, one, when involved with a particular case and subject to the rules of ethical conduct of the court before which a case is pending, and as noted above, two, where no case is pending, are subject to the ethical rules of the attorney's state of licensure, unless choice of law principles direct the attorney to comply with the ethical rules of another jurisdiction. So basically, this is just saying all of the other attorneys in the office are all abiding by the rules of professional conduct in whatever jurisdiction you are licensed in. Oh my gosh, Tuesday, I tell you what, the disrespect in the Congress hearings, that is it reminds me a lot of, if you've seen any of the bad rulers that have gotten called out, in various international courts, where they will go in and say, I don't respect the authority that you have. Right? If you can think of a few of the world leaders that have done that, right? They go in, they're like, we want to talk about the bad stuff. And they say, we don't respect your authority. Very similar. I'm not saying she is like those people, but I am saying by acting that way, she is saying, you don't have authority over me. And so that's the scariest part, right? Because when someone starts saying that the government doesn't have power over you, it means you're really narrowing who does have power over you. And that is more of a monarchy type situation. We'll just use the M word here. All right. So yeah. Supervisory misconduct. Rules of 4-8.4a and 4-5.1. Ms. Bondi's principal ethical violation arises from her perversion of the concept of zealous advocacy into an overriding campaign individually and through Messrs. Blanche, Bove, and Martin, which all should have ethical complaints as well, to coerce and intimidate the lawyers they supervise into violating their ethical obligations. In each of these examples addressed discussed above, Miss Bondi and her senior team ordered department lawyers to do things those lawyers were ethically forbidden to do under the threat of suspension or termination, or fired for not having done so. Again, that's pretty bad. That's pretty bad. And then they will go through, I think this is actually a really quick summary here. Here we go. So Erez Ruveni. So here we go. We'll give you a little background here. I know, I like knowing it exists as well, Kelsey. I'm with you. There are others too. I should probably pull some more. It's good to know that people are doing something. Now, whether or not something comes from it is different than the idea that, it's not just, they see it. Like we see it. We know this is happening. All right. Erez Ruveni. Mr. Blanche first suspended and then fired Erez for telling the truth in a federal district court located in Maryland about why Kilmar Garcia was deported to El Salvador. Ms. Bondi endorsed this action in a television broadcast, but Mr. Ruveni was required to make these concessions, hold on a minute, by the duty of candor to the tribunal imposed on him by Maryland Rule 19-303.3A1 and 4. So duty of candor to the court is in every single set of rules of ethics. That means candor means you can't lie to the court, which provide in relevant part an attorney shall not knowingly make a false statement or fact or law to a tribunal or offer evidence that the lawyer knows is false. As noted above, the court thanked Mr. Ruveni no less than 3 separate times for his candor. So this fella was actually following the ethical rules. In subsequent appellate proceedings, 2 judges on a panel of the Fourth Circuit Court of Appeals took special note of the treatment of Mr. Ruveni. Oh my gosh. Of note, in response to the candid responses by the government attorney to the district court's inquiry, that attorney has been put on administrative leave, ostensibly for lack of zealous advocacy. But the duty of zealous representation is tempered by the duty of candor to the court, among other ethical obligations, and the duty to uphold the rule of law, particularly on the part of a government attorney. United States Department of Justice, here's the homepage here, where they're citing, our employees adhere to the highest standards of ethical behavior, mindful that as public servants, we must work to earn the trust of and inspire confidence in the public we serve. I mean, how awful is this, everyone? This always kind of catches me off guard, even though I know about it. But the Department of Justice is supposed to have the highest ethical standards so that we can trust them for prosecuting federal crimes, right? And federal issues. We're supposed to be able to believe and support and believe that they're credible. And that's gone. That's gone right now. I will not tell a lie. It is gone. Now, before you get too worried about it, it's okay, because it's like we still have a lot of other ways of taking care of business at the federal level. But until the DOJ gets itself sorted out, those like 20% of attorneys that were left right now, first of all, probably aren't getting any sleep or eating properly because they're running around with 2,500 cases. But that credibility has been broken. That trust has been broken, and they're going to have to build it back. And because they don't think they've broken it, they won't, right? True, Nazrina, true. Naviosa. I know, aren't these gorgeous? They're from an amazing creator on Etsy. Her shop is closed right now, but when it opens back up again, I'll make sure to let her know. Oh yes, and any taps for the likes would be very much appreciated. There's all kinds of weird stuff going on right now. I don't really understand all of the news stuff, but sure, if you wanted to tap and get some hearts, that would be great. All right, next up, Denise Chow. Somebody told me and I've forgotten it. I feel terrible about it. All right, Miss Chung. Mr. Bove and Mr. Martin sought to get Ms. Chung, an assistant U.S. attorney in the District of Columbia, to open a criminal investigation in a circumstance where she and her senior colleagues agreed that the available evidence was insufficient to support such an action. She also refused to sign a letter to a bank declaring that probable cause existed to justify seizing assets held by that bank. Ms. Chung's conclusions were subsequently, validated by a U.S. magistrate judge and at least one other U.S. attorney's office. I apologize. Aren't I though, Chris? Am I? I'm terrible. That made me laugh. All right, just a minute here. I'm exploding. All right. Got tea. There we go. Tea cures everything. Adams prosecutors, Mr. Bove, Ms. Bondi, accepted the resignations of Ms. Sassoon and almost a dozen other department lawyers handling or told to handle the Adams prosecution. We lost a lot of attorneys and continue to. Right. The Adams prosecution, because they refused to ask a court to dismiss a well-founded indictment as part of a political deal. In her resignation letter addressed to Ms. Bondi, Ms. Sassoon explained that the offering to drop a prosecution in exchange for a promise of assistance would violate Section 1-8.100 of the Department's Justice Manual, the words of which are worth quoting here. Eat a marshmallow. I may try that. The rule... Excuse me. Oh my gosh, I'm so sorry. I'm coming down to the wire on how long I can talk. The rule of law depends upon the even-handed administration of justice. The legal judgments of the Department of Justice must be impartial and insulated from political influence. It is imperative that the department's investigatory and prosecutorial powers be exercised free from partisan consideration. It is a fundamental duty of every employee of the department to ensure that these principles are upheld in all of the department's legal endeavors. She also pointed out that threatening criminal prosecution, even to gain an advantage in a civil litigation, is considered misconduct for an attorney, according to the bar ethics here and the American Bar Association. Ms. Sassoon acknowledged the zealous advocacy memorandum, but said that because she could not see any good faith basis for the proposed deal, to support it in court would violate her duty of candor under New York Rule 3.3. All of the foregoing lawyers, in addition to different rules that apply to each of the department lawyers discussed above, Ms. Bondi's campaign of coercion also prevented all of these lawyers from complying with their own duties to exercise independent professional judgment and render candid advice as required by every relevant jurisdiction. Rule 2.1 of professional conduct, or were terminated for their unwillingness to violate that duty. Ms. Bondi's threat to subject to discipline or terminate any department lawyer who refuses because of their personal judgments to sign a brief or appear in court stands in direct conflict with the department lawyer's duty under Rule 2.1. That duty is binding on a lawyer in every relevant jurisdiction, even if that lawyer is a subordinate acting at the direction of another. So as attorneys, we can't say, we had to do this because our boss made us. That can happen a lot, right? I was just following orders. There is no I was just following orders when it comes to being an attorney, because you have orders, but your number one is the Constitution. And you take an oath to that Constitution. And part of that as attorneys is that we must follow our ethical rules. All right. So that has to be number one. So she might come in and say, well, personal judgment. It's like, that's what ethical rules are. An attorney has to know. An attorney has to know, is this appropriate? Is this not appropriate? And, there are a lot of attorneys out there who have walked away from jobs because of unethical stuff was being asked of them. I myself have gone through that as well, where it was just I couldn't look at myself in the mirror. I'm like, I cannot do what's asked of me and be able to look in the mirror at myself again. So had to walk away. And that does happen. But the fact that it's 2/3 of the Justice Department, that's just, oh my God. If it was just a couple, like, oh, they don't like her. But the entire Department of Justice, like what? So that is very upsetting. All right, so let's fast forward a little bit so we can get kind of here. We've already talked about this one. Okay, so the last piece then is her threat against the administration of justice, which is only a page long, and it happens to be my personal favorite rule, right? So you have to have the administration of justice. If you're not willing to administer justice in the constitutional way, then, you're in the wrong profession. Thank you so much, Steffi. All right, here's my sticky notice back. Letter C, Miss Bondi's actions threaten the administration of justice. Rule 4-8.4D. Rule 4-8.4D provides that a lawyer commits misconduct when she's engaged in conduct in connection with the practice of law that's prejudicial to the administration of justice, including to knowingly or through callous indifference disparage, humiliate, or discriminate against litigants, jurors, witnesses, court personnel, or other lawyers on any basis. So boom, this is exactly what we were looking at with Mr. Orange's criminal trials with his attorneys when they were making objections and going forward. Was like, this is not right, and the way that you're speaking to the judge is not right, and that, and that's a violation. While we acknowledge that this rule focuses on a lawyer's conduct in a specific case, the spirit of the rule is aimed at protecting the administration of justice and the public's confidence in our system of justice, which is shattered. This broad purpose encompasses a range of conduct that seriously undermines the administration of justice. Here, by aggressively implementing a zealous advocacy policy that's directed towards conduct in pending and future judicial proceedings, and which requires her subordinates to routinely violate the rules of professional conduct, Ms. Bondi has elevated loyalty to the person who appointed her, President Orange, over the interests of her client, the United States. The zealous advocacy memorandum itself conflates the two by stating that Mr. Orange sets the interests of the United States, which again is a fundamental piece here that this administration is struggling with. So that's, the plenary bit that that little dude was talking about, the plenary power. I'm trying not to name call, so we'll just call him a little dude. The little dude was talking about, that's what we're talking about here. They do not have that kind of power. Miller, thank you. Thank you. It is the job of an attorney privileged to serve in the Department of Justice, to zealously defend the interests of the United States. Those interests in the overall policy of the United States are set by the nation's chief executive, who's vested by the Constitution with all executive power. Ms. Bondi's memorandum and the campaign of coercion and intimidation she has set in motion to implement go far beyond the particulars of the three examples discussed here. Rather, they influence and are intended to influence the conduct of all department lawyers in every matter. Indeed, because the department is one federal agency focused directly on the law and staffed by lawyers, Ms. Bondi's campaign affects all federal lawyers. Thus, it's profoundly prejudicial to have the administration of justice in both existing and future cases, and accordingly violates the spirit of the rule. Department lawyers have historically seen themselves as setting an example for all government lawyers. The degree to which this proud tradition has now been trampled upon is made apparent by several well-known descriptions of the unique role of the department lawyers. The most famous, deservedly, is the federal prosecutor, a speech delivered in the Great Hall of the Justice Department on April 1st of 1940 by former Solicitor General, then Attorney General, and later Supreme Court Justice Robert H. Jackson at the Second Annual Conference of U.S. Attorneys. The prosecutor has more control over life, liberty, and reputation than any other person in America. This authority has been granted by the people who really wanted the right thing done, wanted crime eliminated, but also wanted the best in our American traditions preserved. Your positions are of such independence and importance that while you are being diligent, strict, and vigorous in law enforcement, you can also afford to be just. Although the government technically loses its case, it has really won if justice has been done. The citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Supreme Court Justice George Sutherland expressed similar sentiments. The United States Attorney is the representative of not of an ordinary party to controversy, but of a sovereignty whose obligations to govern impartiality is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty. To strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So again, with that quote, then we can kind of think of what's happening also with other charges. Like, are there people, I don't know, maybe a former FBI director who's being brought in, or an AG out of New York, right? There are several situations right now where you have to question what's going on. Is your discretion honorable or not? So with that, we will, excuse me, we've got one more little piece here. We count on lawyers to conduct themselves ethically at all times. Justice Department lawyers have a higher obligation. Ms. Bondi has launched a concerted effort to override ethical obligations whenever they stand in the way of achieving her or her superiors' political goals. This conduct is deeply prejudicial to the rule of law and the administration of justice, as well as violation of her own ethical obligations. We urge the Florida Bar to investigate the allegations made here and to take appropriate action. And then we have it signed here by Lawyers Defending American Democracy, Democracy Defenders Fund, Lawyers for the Rule of Law, Richard Abel, Jane Aiken, Anthony Alfieri, Ty Alper, Martha Barnett, Anita Bernstein, Shelley Broderick, Susan Brooks, Virginia Cantor, James Conrad, Scott Cummings, Angela Davis, Evan Falchuk, Nicholas Fells, Helen Friedman, Bennett Gershman, Nancy Gertner, Cynthia Godso, Lisa Griffin, and we're backwards, John Wesley Hall, Stephen Hanlon, G.S. Hans, Barbara Jeff, Associate Justice of the New York Supreme Court, retired, Marcy Kahn, J.D. King, John Koski, Bruce Kulick, Lisa Lerman, Theo Leibman, David Lubin, Richard Lubin, with an E, one's with an A, one's with an E. Bruce Lyons, Stephen Marcus, Howard Matz, Thomas Mella, John T. Montgomery, Carla Moskowitz, Cheryl Nero, Lorraine Norland, Patsy Palmer, Barbara Parente, Russell Pierce, Jeffrey Pakarak, Peggy Kintz, Gershom Ratner, Mitt Reagan, Lauren Rickleen, Cassandra Robertson, Estelle Rogers, Tanina Rostan, Robert Rubinson, David Rudofsky, Philip Schrag, Tony Seabach, Eileen Seidman, R.K. Sheridan, Gary Simpson, David Singleton, Rima Sirota, Abby Smith, Janet Studley, Jeff Schwartz, Bruce Lee Udolph, Rodney Uphoff, I'm sorry, Rodney, Bradley Wendell, Walter White, Lucian Wolson, Ellen Yaroshivsky. I'm going to get it. Hold on, everybody. Ellen Yaroshevsky. Sorry, Ellen. There you go. So that's it. And I just want to, I think it's important to know, right, who the people are, because there's a bunch of them. So we're not alone. We're not screaming into the void. The signatories have signed solely in their individual capacities. Do not do so on behalf of named organizations or other affiliations. So the asterisks are for people saying, as a lawyer, as opposed to my firm. Yaroshevsky. Oh my gosh, thank you so much. Yaroshevsky. Okay, I'm going to just write that down so I don't forget. Yaroshevsky. Oh, thank you so much, everybody. Absolutely. So we'll go, excuse me, let's go back to the first page so we remember what we were doing. And this is part 2, really. An ethics complaint filed by all of those people against, where'd you do it? I'm sorry. Pearl is literally right next to the battery. Don't step on the battery. These are all the people who signed and wanted to be a part of this. So can you stop sniffling? Here's your tail. You can't see it. Go on. Yikes. Off you go. Whew. All right, everybody. Yes, I'll remember. Hopefully. With that, I will let you go so I can go and rest my voice. Again, I'm doing kind of these shorter ones just until I get back 100%. But a lot of people are asking for this one. It will be posted up on my Tube of You very soon. I'm not sure if I'll be coming back on tonight or not. I'll just have to see how I'm feeling. So take care, everybody, and hopefully this was interesting. And if nothing else, there's, teams and teams of lawyers that are saying, well, this is bologna sandwiches. And that always makes me feel better. Take care.